The way you have looked at it, my answer is very simple. The National Assembly was discussing and basically raising issues which they felt many of them were using to justify or to explain why DP Gachagua is actually being impeached. But for us at the Senate, we have decided and we have said this, and it's very simple. We are looking at the facts. We are going to look at each and every accusation that has been laid. If you say that the Deputy President has participated in disinheriting children of his brother, please give me the evidence. I'm not going to be discussing hearsay. If you tell me that it's tribal, I will tell you, Sami, that yes, chances are, in fact, those facts that do exist. He was giving names of individuals who come from his community, but isn't that what the president has done in employing his permanent secretaries, who are now over 100, and yet in reality, yes, Sami.
What do you mean 100 PSs?
Yes.
Mm-hmm. No.
Absolutely.
In total, they're just about
Sami,
51.
The list can come here, I give it to you, brother. Don't challenge that, please.
There are 15 PSs.
Sami, there are some where you have a department which has got 2.
I'm saying.
Okay, let me simplify it for us. PSS and senior government officers in state departments and corporations. There are more than 100. And if I sit down and give you, wait, Sami.
Would have to count.
Sami, the list it started 3 years ago when I was talking about it here. Mm-hmm. Yes, you can run through that list. So what Gachagua has done is not shocking. That is how we've been behaving. What Gachagua has talked about, this was a company. Shares were being distributed. He said the president kept 60%. He was given his percentage. Musalia and Weta got their percentage. That's the reality. So when we in the Senate are looking at this impeachment, we don't see Gachagua as a failure. We don't see Gachagua as a tribalist. We see him as a consequence of this system which has become so dysfunctional that all we do when we seek power, Sami, is to take state resources, to take state opportunities and share them between our friends, our relatives, and our tribesmen. And that is a fact. So let us interrogate that as Kenyans. Let us know Gachagua is an accident. Out of this reality that we are facing, what is our reality? We are a country that is so dysfunctional that we have gotten rid of meritocracy. What we do, we now reward chronism. We reward relatives. Right. We reward those people who helped us win the election because they donated the money. And it does not matter whether we are going to reward somebody who has no capacity because they come from a poor background, because they're a child of a border rider. And what we have done is basically brought that war to the public, and the public is now discussing it. And that is why when people are saying kufa dereva kufa makanga, what Kenyans are telling us is very simple. This system you guys are running, we know it's cooked. So you're either going to get rid of each other so that we can have a new start if there's anything like that can come in. Number 2, or you are going to sit down and agree that you are going to fix the mess that you have created yourselves. And that is where I am. So going to vote in the Senate for me is a matter that I will interrogate. I will look at it. I'll even consider the historical aspect of this.
Welcome to the bold analysis, ladies and gentlemen. One of the most interesting things about the current political discourse in this country on Rigathi Gachagua's impeachment is the common denominator that any other Kenyan is asking, that while the country appreciates the impeachment as a tool of good governance, you have to do it within the confines of the law. And after Parliament did their part of the work, it was time for the Senate to prove its worth, to prove the stature of the House, and to give the country a sober, fair, and just treatment on that impeachment case. Bring the evidence, not fictions. Don't give us stories. Bring the evidence. And to me, that is the most interesting thing that will actually help this country grow from the political shenanigans that are currently being felt. A day after the Senate Speaker, Amason Kingi, requested and made a declaration that the impeachment motion by the Senate cannot be stopped by the National Assembly, anchoring his argument on the doctrine of separation of powers. Today, Justice Chacha Mwita has also issued his position or a verdict on a case that had been lodged in the court by DP Rigathi Gachagwa's lawyers that were making unsuccessful attempts to stop Rigathi Gachagua impeachment. And to some extent, I want to say something about this. Justice Chacha Mwita have said that the court will not overstretch its reach by trying to impede the Senate from its hearing the case against the Deputy President. The courts will not stop the Rigathi Gachagua impeachment, but requested and said that away from a statement that came from Nelson Harvey, that Rigathi Gachagua impeachment will end at the Senate, Justice Chacha Mwita says that the courts have a jurisdiction to interrogate any state organ or entity that acts outside the confines of the law. Now, this has cleared Nelson Harvey argument, who was pouring cold water on Rigathi Gachagua's shoulders when he said that immediately Senate decides the fate of Gachagua, that will be the end of his political tenure. And for better part of Tuesday, lawyers, the social media lawyers and the emissaries that are working for the state have been desperately pushing a narrative, and they've even crafted a statement that Rigathi Gachagua was calling a press briefing at 7:30 so that he can actually resign. I've seen Ahmed Nasir asking Rigathi Gachagua that the best thing he should do is to resign. Of course, Ahmed Nasir does not believe in Senate, neither in courts, because of his relationship with the Supreme Court. I want you to listen to Chacha Mwita.
If a state organ fails to abide by any of the values and principles in the Constitution, the court exercising its mandate under Article 165 sub-Article 3 will come in and investigate whether anything said to have been done under the authority of the Constitution is inconsistent with or in contravention of the Constitution. It was in this respect the Supreme Court stated in a matter case that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the court is restricted to the doctrine of separation of powers, to deciding on matters of individual rights and fundamental freedom. The Supreme Court then stated that in the exercise of their wide political powers, both the county, read National Assembly, and the Senate cannot act outside the confines of the Constitution and the law. For to do so would invariably invite the court's intervention. End of quote. In other words, the constitutional processes are not about a dash to the finish line. They have constitutional imperatives that must be complied with, and if not, such infractions will not be out of reach of our Constitution. The timelines given in the Constitution are on the premise that its processes will comply with the constitutional requirement. Where there is an allegation that the constitutional imperatives have not been complied with, the affected person has recourse to the courts, and the court will rise to the occasion and consider whether the state organ complied with the Constitution or the law. In that respect, ours is a constitution of hope and promise, that institutions established under the Constitution will comply with its fundamental principles, and the promise that the Constitution is supreme and any act or omission in contravention of the Constitution is invalid. In other words, it does not matter how far the process may have gone, since no action is out of reach of our Constitution. This is what Lord Denning had in mind when he stated many years back that if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have the court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. Article 2, Sub-Article 4 of our Constitution is not only the hope, but also the promise of our Constitution that we must abide by the constitutional dictates, for any act or omission in contravention of the Constitution is invalid. In that respect, I conclude this matter, and this is what I say. Having considered the application and argument by parties, the Constitution and the President, the prayer for grant of conservatory order is declined. However, in view of the issues raised in this petition, which also appear to relate to those in petition E522 of 2024, which has been certified for purpose of appointing a bench of an even number of judges to hear, I certify this petition as raising substantial questions of law and of public interest in terms of Article 165, Sub-Article 4 of the Constitution. This file is to be placed before the Honorable Chief Justice to consider appointing an uneven number of judges to hear this petition. Given the close proximity of the issues in this petition and those in petition E522, the Honorable Chief Justice may consider whether this petition may be heard by the same bench appointed to hear petition E522. I make no orders on course. Thank you.
Now, Chacha Mwita also put a point, or also weighed on the concerns raised about the public participation. And it was about because there was an argument of what the Deputy President's team argued about the way the public participation was done. And to some extent, he also argued that the public participation was not done in a fair and justice, did not serve, was not genuine, and also did not meet the threshold. So one of the takeaways here is Chacha Mwita is saying that the courts will checkmate the process. They will perfect the process, and for the sake of perfection. Remember, this is a case that is going to give us precedents.
Kenya enacted the Constitution. They gave this court jurisdiction to hear and determine anything said to be done in accordance with the Constitution. Senior counsel asserts that Article 23 requires the court to uphold the Bill of Rights, an authority conferred on this court, while Article 23.3 gives the court power to grant conservatory orders in appropriate cases. According to senior counsel, Article 25C is clear that the right to a fair hearing trial cannot be limited. He maintains that the petitioner's right to a fair hearing has been violated, that public participation was not properly conducted, as the Supreme Court directed in the British American tobacco case, that this court has jurisdiction to investigate the matter since the National Assembly acted as a quasi-judicial body. In the Council's view, the 12 days provided for in Standing Order number 64 of the National Assembly Standing Orders violates Article 50, Sub-Article 1 of the Constitution. Further, public participation was to take place at county headquarters until the High Court at Kerugoya directed that public participation be conducted at constituency level. The notice to that effect was issued late, and according to Council, that explains why the turnout was a paltry 224,000 people. who took part during the exercise. Public participation was not therefore meaningful and did not comply with Article 118 of the Constitution. Mr. Muite, Senior Counsel, again cited the decision in Itaru Peter Munya and the bundle of their documents on the public as that public interest in constitutional values is the basis for granting a conservatory order. The resolution was transmitted to the Senate immediately, and immediately after the Senate set the process for trial in motion, posing the question, why the haste? Senior Counsel again cites the decision in Joseph Enoch Aura on the minimum requirement for effective and meaningful public participation and urges the court to grant a conservatory order. Mr. Macharia, who took up after, argued.
So without much ado, I want us to delve into this analysis and look at a number of some 6 cases, petitions that had gone to the courts. Now the petitions has increased to 26. More than 26 Kenyans and entities have gone to court to ask the court to halt the impeachment process. But I find that is one of the prayers that cannot be granted, even looking at the public interest. Because even the senators have the anxiety to look into the Rigathi Gachagua impeachment. And the Senate is part of the process. From the National Assembly, the Senate is the trial chamber. And the Senate is part of the process that cannot be denied an opportunity to interrogate a first ever impeachment of the deputy president. So some of the legal experts, some of the legal minds around the deputy president, to my end, are also just pushing some prayers for the sake of minting some cash from here and there. But I don't see some of those minds really pushing a legitimate call for the courts to halt Rigathi Gachagua impeachment. Tomorrow, there is a case, the bench that was constituted by Lady Justice Martha Koome is going to meet at 8 a.m. At the same time, the Senate is supposed to start the proceedings, and they're supposed to give their arguments based on what actually have been said, and based on whether that process should continue or not. So if the process will be going on, I don't know whether a court injunction will come, make the session to stop it. So Rigathi must also look very careful and just interrogate who is really pushing a genuine cause for me and who is just there pushing to get some visibility, so that your law firm can also get visibility in such a case. Because someone was also telling me that some law firms are just throwing their weight in it so that they can get visibility, and probably they've known that that is something going on. There was a story by the Citizen, that newspaper, that some cool tycoons were already consolidating some funds that have been fundraising. The Rigathi Gachagua circle within government have been fundraising to support his legal battle in the court against the deputy, against the state. So it's a very interesting bit. I'm looking at some very interesting bits on how things would actually move. But at this point, I want us to look at some very critical cases, and I'm going to do reference from Hari Karanja, DTM, is the person that has penned down a very interesting breakdown on these petitions, and let's look at each one of them, because this is part of what has been consolidated, and the court is supposed to get it tomorrow. So this is an interesting one that I think you can see. There is a first petition by Jeremiah Gitari Njagi. Jeremiah Gitari Njagi is asking, his clauses are the violation of Article 47 and 50 of the Constitution. The petition argues that impeachment process violates the deputy president's right for fair administrative action and a fair hearing. Looking at how the deputy president was condemned before judged, of course condemned before he was judged. The public participation happened before his side of the story was not heard. And he argued that the choices, the public participation that was told, was just speaking about it before even getting his side of the story. The second claim about from this petition by Jeremiah Gitari Njagi is political instability. The petitioners suggest that the impeachment is politically motivated and could destabilize the country. This is also something that Rigathi Gachagua, I've seen a clique of some analysts and lawyers around Rigathi Gachagua have really been telling the country that the country risks going down the drain if looking at how they would actually, Kenya Kwanza looks very weak, becoming more weak, looking at how they would manage Rigathi Gachagua impeachment. The second one is a petition by Honorable Rigathi Gachagua himself. These are key constitutional issues that Rigathi Gachagua has raised. And so I'm reading it so that I one by one will try to break down and find out which one has been violated and which one do you think does not hold water, so that we can also just make a preempt on what is in the offing. Number one, failure to meet the impeachment threshold. The petitioner highlights that the impeachment motion does not meet the gross violation of the Constitution threshold required by Article 145. The petitioner also argues that the charges are vague, violating the need for specificity under Standing Order 64. There is this word called violation of gross violation. The word gross violation should be deleted so that people become specific, because someone says gross violation, then tables a number of arguments and say this is gross violation. I think this case will really give us a very good glimpse on how impeachment should be handled even in future. Number two, Rigathi is talking about precedents from the Wambura Appeal 2014. The petition references this ruling, which set the standard for impeachment cases. It suggests that the National Assembly has failed to meet the requisite burden of proof. For Wambura case, it was the same that Martin Wambura survived. The first Embu governor really saw hell. The first Embu governor suffered numerous impeachment motions. The same with, I think, Kivutha Kibwana. And even Kivutha Kibwana called for dissolution of the county assembly of Makueni, for the county government of Makueni, because the MCS were really on his neck. So the precedent from Wambura Appeal 2014 is you need to provide proof. So that is why I think the courts are also really looking at, the Senate is looking at what actually they will bring on table. There is a petition by Victor Okoth. Victor Okoth is talking about bias and prejudicial conducts. The petitioner argues that the impeachment process is biased, violating the deputy president's right to a fair hearing under Article 50. There is something that the state is just assuming, but a pronouncement by the Speaker of the National Assembly, Moses Wetangula, and the Deputy Gladys Sholei could be a blessing in disguise for the Deputy President. Because, and I think when I was analyzing this, my first analysis on this impeachment, I raised these issues and I said that on the conduct on how those fellows handled Rigathi Gachagua's impeachment, that cannot go unnoticed. And if someone wants the country to assume that that was just an order and there is no question that should be raised on that, then he or she is just dishonest. Because the truth of the matter here is that there is a big concern that has to be answered. Where is the neutrality? And you could see that the Senate Speaker, Amason Kingi, even said that senators should not comment about it. But on that end, you could see the speakers of the Speaker and the Deputy going in public and speaking about it. Victor is talking about the second part is public participation. The petitioner also contends the impeachment process lacked proper public participation, which violates Article 181 of the Constitution. Okay? So you look at that. That is a petition by Victor Okoth. Then there is a petition by Miruru Waweru and all. His first part is separation of powers. The petition highlights the potential abuse of parliamentary authority, suggesting that the impeachment process is being used to settle political scores rather than constitutional accountability. This challenges Article 94(4), which mandates Parliament to act within the constitutional boundaries. Separation of powers. And I want to speak about this for a minute, if you allow us. This process going on in Parliament, there is no doubt that the impeachment is a political process. And impeachment is a political tool. It is a weapon that is normally at the disposal of, it's a disposal with the person with numbers. So on this one, they need to be very careful. They need to be very careful because it will set a precedence as to this is how the future and it should be done. And there is this issue about separation of powers. And Parliament the two houses have been bragging about it, that what they've passed should not be debated in the courts. While there are some other things that have been going to court. Number 2 is improper grounds for impeachment. The petition argues that the charges in the impeachment motion do not meet the constitutional threshold. I want to look at the very last one. Petition by Dr. Clarence Eboso, Mweresa and Wajiru Mwangi. Key constitutional issues. Freedom of expression and representation. The petitioners argue that the impeachment process violates Article 32 and 33, which protect freedom of expression and the right to political representation. Of course, this one is supposed to respond to the shareholding narrative that did not really sit well with many people in this country. Constitutional democracy. The petition also raises concerns about undermining the values of Article 10, which enshrines national values including democracy and participation of the people. That also questions people's participation in Rigathi Gachagwa's impeachment. Then there is a petition by Black Excellence. Black Excellence is saying lack of public participation, unconstitutional use of impeachment, and so on and so forth. So Harry is saying that at the heart of these positions are serious constitutional questions that could have profound influence on Kenya's political future. The petitioners raise concerns about fairness, public involvement, and the potential use of impeachment powers for political ends. They touch on core principles that affect every Kenyan's trust in how their leaders are held accountable. Now, there is a critical part in this process that both the Senate and the courts are going to help. And I wish that, like we said from the word go, it is a very risky path, but it will be more rewarding if he goes through it than just going to resign. I will analyze that sometime. That is a talk I've never probably entertained. But now we're meeting the wire. We're going to the wire. We will have to look at that. More stricter legal grounds on impeachment will be needed. At the end of this process, the court will actually see the necessity of, through a legislation or a constitutional means, if there is going to be some constitutional reforms. I've seen the process, the NADCO going down the swamp. That NADCO document has gone down the swamp. It's not telling, doesn't have a head or tail. But if there would be anyone that will think of some constitutional reforms, even in the office of the presidency, then more stricter grounds will be needed. And people really need to see. I support what the Manyata Member of Parliament, Mukunji, is saying that an impeachment of the Deputy President should be harbored by the IEBC. And between the courts, the people that are supposed to do public participation to collect the views of the people is supposed to be the voters. So when we talk of a significant support, remember BBI, the way BBI went to county assemblies, and it was the President Uhuru Kenyatta managed to get his way through the county assemblies. Then it went through some public participation. Now, I think the Deputy President's one needs to be done through it needs to be IBC approved. IBC is the one to collect the signatures. As much as we collect the signatures of the MPs, that role should not be delegated to the members of parliament, because they work at the behest of the weapon holder, who is the leader in charge. Political battles cannot be fought using constitutional means. That is one of the takeaways that should come out. And the court should be looking at, and even the Senate, the grounds that have been created there do not really show the adherence to probably promoting good governance. You can see MPs taking the microphones in funerals and weddings saying that they are regretting voting to impeach Rigathi because they were demanding, or they knew that people from their tribes were going to take over those positions. So it means that the whole process was just led by greed and just a feeling that I am going to get something in return. And if that is the ground, then I think we take it smoothly this way, then we shall have opened a new window for political battles to be fought using constitutional mechanisms. That constitutional mechanism is being abused. The courts could still have to checkmate the impeachment process. I think Nelson had the argument that there should be a closure in the Senate, should not be entertained, and the courts must stand their ground. Just like the impeachment of governors. Just like the impeachment of governors, even this one should not hold any water. Even this one should actually survive. Lastly is about the place of PP in future impeachments, the place of public participation. It should be well defined, and I think by the end of this process, whether Rigathi goes home or Rigathi survives, the country shall have a sober debate to argue and discuss on what really it needs for itself. Thank you.